good morning for Professor Enders.
Yeah, good morning.
Jadi di sesi kali ini kita akan berkomunikasi langsung dengan Prof. Enders. Sudah ada mahasiswa yang menyampaikan pertanyaan dan saya telah memilih mungkin sekitar 10 pertanyaan yang disampaikan kepada Prof. Enders dari banyak aspek, mulai dari tentang hak dasar, tentang kebebasan beragama, tentang kelompok difabel begitu, dan nanti akan dijawab oleh Prof. Enders, dan setelahnya nanti jika masih ada waktu, Anda yang masih memiliki pertanyaan atau tidak mengerti dapat mengajukan pertanyaan kembali kepada Prof. Enders. So I just explained to the student that in this session we will have question and answer session with Prof. Enders, and I have sent to you the question that have been made by the student. I think concerning the basic right, concerning the freedom of religion, the disabled person rights, and then you will answer the question. And if we have time, and at the end of the session, the student can ask the other question if there is something not clear enough from your answer.
Yeah, okay.
So, please, time and screen is yours.
Yeah, so, okay. Thank you for introducing me, and welcome to all the students, all the participants of this final part of my lecture. It is supposed to be questions and answers, and will highlight the Constitution of the Federal Republic of Germany, so the Grundgesetz, the basic law, with special regard to the jurisprudence of the Federal Constitutional Court. So my name is Christoph Enders, as you already know, and I'm supported by Konrad Schröder. He is my research assistant and is in charge here for technical, but also legal support in case this should be necessary. Now, we have received several questions regarding my lectures within this 3-in-1 format of your faculty. And we have put all of these questions in a new order, more or less related to the structure of my lectures. So this order is or will be roughly questions related to part A of my lecture, so concerning the basics of German constitutional law. This was the part A of the lecture. Then second, questions related to part B. This was the second part related concerning freedom of assembly and freedom of opinion and expressions. And then lastly, questions related to part C concerning the freedom of religion. And we also have prepared some slides again, to make it, I hope so, hopefully to make it easier. So we start, and Konrad Schröder, if I forget a slide or so, please remember that I share this slide. So we start with question 1 related to part A, and Ahmad Faris Nurul Mustafa, Ahmad asks whether the constitutional complaint as laid down in the German basic law could serve as a model for Indonesian constitutional law and practice if it could be adopted in Indonesia to protect the citizens' rights effectively. My answer is, and perhaps we should have, no, but like that? No, wo drücken Sie? Ah, okay. My answer is, of course, this instrument, the constitutional complaint, this instrument to protect fundamental rights could be adopted within the Indonesian constitutional framework. You have to be aware, though, that there are several preconditions. As I have pointed out during my lecture, there are several preconditions that have to be fulfilled to make the Federal Constitutional Court decide the case and the concrete constitutional question put forward by the complainant. Have a look on the slide. There has to be, especially, there has to be a specific concernment. This is the second point here. In every case, the complainant needs to be concerned by the state.
Sorry. Mohon yang lain di mute.
Okay. Okay, we continue. There has to be a concernment. The complainant needs to be concerned by the state measures, and he or she has to exhaust all given legal remedies. Taking this into account, we have to note that in 2019, 88% of all constitutional complaints have not been admitted for the decision. So only 12% have been admitted. The others have been rejected by the Federal Constitutional Court. And merely 1.4% of all constitutional complaints have been successful. So you have to take that into account if you figure adopting this instrument of the constitutional complaint for Indonesian constitutional law and procedure. So this is question 1. I'm continuing with question 2. Adam Adi Pravira. Adam asked whether the German state does provide opportunities for people with disabilities to enter the government and to participate in government and other state services. Also if these disabled persons do get the same share of income as citizens in general. The answer is yes, this is so, and is in general, the answer is in general given by our constitution of the basic law. Looking here at Article 3, paragraph 3 of the basic law and Article 33, paragraph 2 of the basic law. So you see that anyone, also disabled persons, should have the same rights and therefore the same opportunities to develop themselves and perform their freedoms. Therefore, if a position is put out for tender, the official announcement says, oh no, this is the, we don't have the text of this one, do we? No. The official announcement says, severely disabled applicants with equal qualification and aptitude will be given preferential consideration. So this is the usual text if a position is put out for tender. It would be illegal if the German state would discriminate against someone because of his or her disability. And as an example, I show you Wolfgang Schäuble. He used to be the Minister or Secretary of the Interior of the Federal Republic of Germany, and now today actually is the President of the German Bundestag, the chief of the German Parliament. Yeah. So, and he obviously is due to assassination. So an act of terrorism is a disabled person. Of course, second, German civil law as well. So this was for the state and what the state has to do, and if the state is obliged to berücksichtigen, to consider disabled persons. Also, the German civil law as well prohibits private individuals from discriminating against a person because of his or her disability. Of course, in everyday life, there may occur cases of disadvantage or even discrimination. These are, however, rather factual and, of course, not in compliance with the law, which is to prevent such injuries. So in total or in general, the answer to this question was yes, disabled persons do have the same rights and in general also the same opportunities to perform these rights. I'm continuing with question 3. The question was put by Ricky Kairu Hendarji. I don't know if it did pronounce it correctly. So Ricky's question is actually 3 questions and not so easy to answer. I start with the first part of this question, of Ricky's question. Why would the German Grundgesetz, the basic law, have been intended as a merely temporary placeholder, as Article 146 of the basic law, you see this on the slide, Article 146 shows or states that the basic law becomes void. Becomes void when Germany will be reunified and the German people will freely adopt a new constitution to be applied to Germany as a whole. And this question already has 2 parts. And why is it that the German people did not make use of that option until today? There's no new constitution given since 1990. So the date of the reunification of the 2 parts of Germany? My answer is from 1949 up to 1990, the Basic Law was the constitution of the western part of the former Deutsches Reich, so the German Empire. And the Basic Law was the constitution of the western part, so of the Federal Republic of Germany. The eastern part was integrated into the socialist world, as you probably know, and was a state of its own and had a constitution of its own. This was the German Democratic Republic. This is the reason why the creators of the Basic Law meant the Basic Law to be a placeholder, merely a placeholder for just a transitional period. They said in 1949, people in the East are not really free, not self-determined, but under a dictatorship. The entire German people will be called upon to complete the unity and freedom of Germany someday in free determination. Then a new constitution should be drafted and enforced. Should and could be drafted and enforced. In 1990, Germany was, as you know, reunified. The Eastern German Democratic Republic, after a peaceful revolution, joined the Western Federal Republic of Germany. To be more precise, the newly founded or formed Länder within the German Democratic Republic, the states within the German Democratic Republic, the states of the eastern part, acceded to the Western state. However, the Basic Law has been amended, but never has been replaced by a totally new constitution. So until today, no use was made of this Article 146 and its option to draft and enforce a totally new constitution. This observation, this fact, results in two further questions as I see it. Is Article 146 of the Basic Law still valid? Can the German people still make use of this empowerment to abolish the former Basic Law and instead enforce a new constitution? Or has this option expired? So is this article not valid anymore because Germany obviously is already unified and has a constitution. This is the old Basic Law, is the new constitution. So perhaps this Article 146 is not valid anymore. The other question is, if this option of Article 146 is still in force, so if it is still valid, why don't the German people make use of it? Why don't they draft and enforce a new constitution? Answer to the first question, is Article 146 still in force? The empowerment of Article 146 is still in force and has not yet expired. This is, as I see it, the standpoint of most legal scholars in Germany. And as far as I see, also the standpoint of the Federal Constitutional Court. So Article 146 is still valid and delivers the option of making a new constitution. So this leads to the second question. Why don't the German people make use of it? Why don't we draft and enforce a new constitution? So this is a political question. Probably, as I see it, everyone is afraid of the trouble, the arguments and quarrels a process of drafting a new constitution would cause. So no one is in favor of taking this option of Article 146, because the basic law as it is, as it has developed with some amendments regarding the reunification, but more or less the same basic law as we have since the year 1949. This basic law works quite well. And so no one wants to take this option of Article 146. Which is a necessary option more or less because of the Article 79, paragraph 3, you see on the slide 2, because this Article 79, paragraph 3, prohibits amendments to the German basic law that would abolish basic principles. So the only way to get over this Article 79, paragraph 3 is or will be take the option of Article 146 and draft and enforce a totally new constitution. But it's not the situation is not, the political situation is not in favor of this option. Second question, still of Ricky, is, and it's still part, more or less part A of my lecture, is militant democracy truly an appropriate way of dealing with the so-called paradox of democracy? Isn't there an inherent arbitrariness in the decision as to what constitutes the enemies of democracy? Or I put it in another way, another words, is the slogan, so this is my words, is the slogan "no freedom for the enemies of freedom" or "no tolerance for the intolerant"? Is this a convincing slogan or principle? So I guess this, I hope I got the sense of this question of Ricky correctly. This is again, I'd say, so my answer, this is again, firstly, a political question. And John Stuart Mill on freedom probably would quite obviously not have agreed that no freedom for the enemies of freedom is a valid slogan or principle within a free democratic state. However, what we can say is the fathers and mothers of the basic law, so the constitution creating legislature, have chosen to build the free democratic order of this basic law on this principle, no freedom for the enemies of freedom, as shows, you see the slide, as shows Article 21, paragraph 2 of the Basic Law. However, I would like to draw your attention on how the Federal Constitutional Court interprets this statutory rule of Article 21, paragraph 2. So it's a little bit lot of text. Important is, as I think, especially head note 6. So these are the head notes of the judgment of the Federal Constitutional Court in the NPD case. So NPD, you see that in the line beneath, in the text line beneath. NPD is the National Democratic Party, so right-wing party. And head note 6 of this NPD judgment concerning the National Democratic Party is quite important. You see that it's not against, it is not allowed, even if you even if you build the democratic order on this principle, no freedom for the enemies of freedom, even then it is not allowed to prohibit views or an ideology. So this is said in this head note 6. It is necessary that this party or movement must take real action against the free democratic basic order. Okay, so this is not only prohibition of views or ideology, but of real actions that are dangerous for the community. So so this would be my answer to that. Of course, it's not so easy to say when does a party or movement reach this limit. Yeah, so this is not so easy. And by the way, the Federal Constitutional Court pointed out that the NPD, the National Democratic Party, is too small and too weak to cause a danger for the Federal Republic of Germany and its democratic order. So it was not forbidden by the Federal Constitutional Court. So last of Ricky's questions, still Ricky, as I understand it, this is concerning the unmittelbare Trittwirkung.
The third party effect.
Yeah, genau, that's the third party effect of fundamental rights. And Ricky asked if a user posted a content, for example, involving immigrants, and then the company took down the content because it's considered promoting hate speech, and it violates the policy of this company. Do they, I suppose, the fundamental rights of the violated or insulted people, do they bind the private company? And can a private company block content that is, as Ricky says, awful but lawful, setting up and following their own compliance rules? And finally, what if a private company takes on a very dominant position, similar to the state's position? will it then be bound by the fundamental rights? This is all about the ich finde es wieder nicht indirect. No, what is the third? Thank you. The third party effect of the fundamental rights. So my answers. Firstly, do I need this? Yeah. Firstly, this is all much discussed in Germany and an issue that's in progress. So there is no totally clear answer to these very good questions. Second, private persons and companies are in general free because they are bearers of fundamental rights and are not bound directly by the fundamental rights of the basic law, as shows Article 1, paragraph 3 of the basic law. It's the state that is bound by the fundamental rights. It's not the private persons and also not the private companies who are, which are private persons in a legal sense. Then it is up to the legislature because of that, it is up to the legislature to regulate the communication within the internet and to fulfill their duty to protect, for example, and especially the right to personal honor of any member of the society. So the legislator is called upon to safeguard, to protect the rights of everyone, and also, for example, the right to personal honor of any member of the society, also concerning the communication in the internet. Further, as private companies are not bound directly, I show you again Article 1, paragraph 3, as private companies are not bound directly by the fundamental rights, they are free to set their own standards as long as these are not illegal. A company then would be free, in general, free to delete posts that contradict the company's compliance rules, or even to exclude users from their platform, from their service. If this company, however, has an absolute monopoly, and this was the last part of the question of Ricky, if this company has an absolute monopoly, this might be seen and will be seen different. They need at least very good reasons for that kind of measures. So if there is if they have a very strong position like the state, we would see that different. In general, however, you may say that there is a tendency in German constitutional law, there is a tendency of an increasing use of fundamental rights as constitutional principles via the indirect third party effect. This, of course, safeguards or puts forward the legal position of one side or of one part of a legal relationship, but in total restricts autonomy as a basis of civil law. So this is, as I would say, not only a good development, but also bears some risks. We are coming to question 6, and now it's part B, concerning part B of the lecture. So it's about the freedom of assembly and of expression. Adam Adi Pravira asks, to what extent is the freedom of thought protected? Is there any special limit? And to answer this question, I show you again the slide with the text of Article 5 of the Basic Law. So we have a look on this article, which safeguards the freedom of opinion and expression. And we note, point 1, freedom of thought, because Adam asks for the freedom of thought. Freedom of thought means, of course, freedom of opinion and expression, to express thoughts. It is not merely the thought, the idea that is safeguarded, but its expression. Thus, this is the freedom of speech, which is safeguarded as long as it spreads ideas within the public. The message as such is safeguarded. It is not allowed, no, not yet. It is not allowed, though, to violate life or physical integrity of other persons, or to insult others, as shows paragraph 2 of Article 5. These rights shall find their limits. Yeah, so there are limits, of course, to the freedom of opinion and expression, to the freedom of speech. And of course, one limit would be the life and physical integrity of other persons, and another limit would be the personal honor of other persons. So they should not be insulted. I have explained that before and in more detail in part B, so the second part of the lecture. So should now no. The poster is later, huh? Kommt später. Yeah, okay. So this was the answer to the question 6, question of Adam. Now we continue and come to the question 7. Suki, I don't know if I pronounce it correctly, Suki Miftahul asks
Suci Miftahul Aina.
Ah?
Suci Miftahul Aina.
Yeah, okay. This is not so easy for me. Sorry. Okay, now she, I guess she, yeah, is it correct? She is a woman. Yeah. Okay, she asks a question concerning a statement, obviously, of the German embassy, that during the COVID-19 pandemic, the freedom of assembly, I guess in Germany, has been and should be upheld and not abolished or not even suspended. And she asked, how about safeguarding the life and physical integrity of persons? Because I guess this is the intention of the question, because people could be infected. So their physical integrity could be endangered during assemblies or by assemblies? My answer is, indeed, freedom of assembly has not been abolished or suspended during the pandemic in Germany, but has been restricted in many ways. And it should be very clear that even within an assembly, people have, for example, to wear a face covering, a mask. This rule is made to safeguard lives and has to be respected by everyone. An assembly that would not respect this rule or other rules of this kind and of this function could be abolished or could be dispersed. The main thing is, as I have already painted out, a ban on all assemblies and any kind of assembly would be disproportionate. Setting rules for assemblies requires a concrete case-by-case consideration. So a concrete case-by-case consideration is constitutionally required. This is why at the beginning of the COVID-19 pandemic, the Federal Constitutional Court rejected blanket bans on assemblies, holding the authorities had failed to consider milder or less severe means than a blanket ban. The authorities had missed to consider the single case, and this was, as the Federal Constitutional Court decided, this was unconstitutional. I am continuing to, so this was my answer. I'm continuing to question 8, also concerning part B. Gumilang Aksan Pramuditya, again a little bit complicated. So asks or tells us that radical and extremist views are an issue in Indonesia, and asks if Germany does face the same problem. So extremist, radical and extremist views. And asks further, at which point do the government intervene? My answer is yes, of course, we do have the same kind of problems. And limitation of freedom of speech, and also freedom of assembly, because it spreads a hateful message, is always a problem. Why? Because speech should be as free and uncurtailed as ever possible. We have talked about the limits or limitations of freedom of speech in general. This is, as you see, Article 5, paragraph 2, not to violate or insult others. However, also public order and public peace are at stake. I'll give you, instead of a general answer to this question, I'll give you one more example. That is, of course, this example does not mean the solution of the problem, but just shows the difficulty of setting up limits for the freedom of speech. Our criminal code safeguards public peace by the provision of section 130. I'll show you that in the next step. But just the example before, very recent example, a very recent case, a right-wing movement or party presented during the election campaign we had now, presented a poster, and this poster said, hang the green ones. Hang the green ones. So yeah, I translate this for you. Hängt die Grünen. That means hang the green ones. Hang the, and it's might be understood as hang the members of the Green Party. So hang them up. So like kill the members of the Green Party. However, you see in a the movement or party was the so-called third way. You see this the third way. They call themselves the third way. So, and their posters have a green color, as you see. So in very small letters beneath this headline, hang the green ones, in very small letters, there was added a sentence that said, hang or spread the green colored posters of our party, the green colored posters of our party all over the country. Spread them, the green colored posters, all over our country. So giving still another sense of this headline. So is this allowed? Is this a possible way to express one's opinion, or is it violating the law, especially section 130, paragraph 1 of the German Criminal Code? Perhaps you don't have to read it, the whole text, the whole of the text, but it's safeguarding, as you see, the public peace. In the first line, disturbance of the public peace is forbidden. So, and this is safeguarding the public peace. And indeed, a court, the higher administrative court, decided that this poster, hang the green ones, although it has this kind of explanation in smaller letters, is violating section 103, paragraph 1 of the German Criminal Code. And so this poster was forbidden, and the third way, this party had to take these posters down because they violated, as the court said, public peace. So this was the administrative court in second instance, so the higher administrative court. The administrative court had said, no, this is legal, this is just one way to express one quite rough or unfriendly or what way to express one's opinion, but it's a expression of opinion. It's not forbidden. But the second instance, the court of the second instance, the higher administrative court said that this is forbidden because it violates paragraph 130. So question 9, this is now concerning part C of the lecture, so the freedom of religion. And Muhammad Dafa, wait, I can't read my own. Muhammad Dafa Atala asks, does the German constitution allow for or even protect atheism? that's the way I understood what you asked. Is this protected by the German constitution? And this time the answer is quite clear. Yes, German constitution does protect even atheism. Either um, either you say that atheism is a religion of its own, so it's protected by the freedom of religion, or you say it is at least a philosophical, a philosopher, no, wait, philosophical, so now I have it, philosophical creed. um, and then it's protected anyways by Article 4 of the Basic Law. So also atheism is allowed and is protected by the fundamental rights of one possible personal standpoint of persons. Oh, no. Last question, as I guess, is question 10 by Putri Alifa. And I guess she asks, okay, thank you. She asks, there are 5 states, so 5 Länder in Germany out of 16, 5 states that prohibit Muslim teachers wearing a headscarf. And what is my opinion? How do I see this? My answer is, as far as I know, I may be wrong, I may be mistaken here. As far as I know, actually only one state, and this is Berlin, the state of Berlin, the city of Berlin. It's also a state, a Land of the Federal Republic of Germany. Only one state, Berlin, strictly prohibits teachers showing religious symbols in public school. That means also the wearing of the headscarf is prohibited in Berlin by the Berlin law concerning these cases. This regulation is, as I think, unconstitutional and will or would be abolished if the FCC, the Federal Constitutional Court, would decide the case, or the same if the Constitutional Court of the Land Berlin would decide the case. This regulation should be and probably would be abolished, held unconstitutional, because it's not in accordance with the Constitution of the Basic Law as interpreted by the Federal Constitutional Court in its decision of 2015. Yeah. But this, you have to know that this decision only concerned a special land, a special state of the German Federal Republic of Germany, North Rhine-Westphalia. So, and this case has been decided. Of course, what the Constitutional Court, the Federal Constitutional Court said and decided is valid and sets the principle also for the rest of the Federal Republic of Germany. But first, it's the Länder are in charge and are competent to make their own regulations, because school is regulated by the states, so the Länder of the Federal Republic of Germany. So, and this was these are my answers to all the questions we have received, and we can try in, let's say, 5 to 10 more minutes to answer further questions if there are any further questions. So for now, I thank you very much. And yeah, Ali.
Yeah. Okay, thank you, Professor Anders. And you have 5 or 10 minutes if any other further question from the student. Silakan jika ada 1 atau 2 pertanyaan secara langsung dapat disampaikan. Of course, you can ask question directly by English or maybe by in Indonesia, in bahasa, it's also no problem. Silakan, ada yang mau diperjelas? Tadi yang banyak menyampaikan pertanyaan, siapa tadi? Ada Suci, Miftahul, Aina.
Ricky juga Pak, banyak.
Siapa?
Ricky Khairu.
Ya, Ricky, ada Ricky. Tadi ada sih. Ricky Khairu. Ada? Siapa? Jika ada langsung saja silakan. Ricky Khairu Hendarji, malah kelihatan fotonya. Silakan. Oke, tidak ada. Oke, Professor Anders, there is no further question.
Let me say this: if anyone thinks about all these informations and perhaps has a question during the following days or so, he or she might also send an email or send an email to you, and you give it to me, and we try to answer this question in an email as precisely as possible. If there is something still unclear, of course, I cannot answer all questions. So some things I can't, or let me say like this, I can't make things clearer as they are. Not everything is that clear, and also the Federal Constitutional Court is not every time 100% clear in that what it says. So yeah. But okay.
Thank you. Oke, tidak ada pertanyaan ya. Oke, we have one question, Professor Ender. Is this okay? Ya, silakan. Ricky Khairu.
Hello.
Ya, silakan.
Right. Excuse me for earlier. I got connection issues. Right. I would like to ask again, maybe to clarify what you have said regarding the. It's in German. I think Freiheitlich Demokratisch Rundordnung and the Drittwirkung. So I haven't clear what you explained. I mean, there's a case where a user who is a well-known member of the AFD posted the content involving immigrants. Then the company took down the content. It is considered promoting hate speech and violates the policy. Do somehow the Drittwirkung affect the company's policy in a way that makes what the private company's action considered can be considered unconstitutional? Thank you.
Okay. You got the question, Professor Anders?
About the tone quality, the sound quality is not so good. I must say. I guess I understood that this is the same, the question you have already asked about the third party effect, and if the fundamental rights are binding also for private companies. And if, I don't know, which company was it, with the AfD or was? Twitter, was it Twitter?
Twitter, Facebook.
Yeah, so I just can repeat what I have pointed out, that in general, each of these companies is a private person. Yeah, so these private persons can set up their own rules in general, and so they are also they also may abolish, or was das absetzen, abolish the, oder wie sagt man da, delete a post of the AfD if they think this is undecent or so. Yeah, so it's a thing of private, of civil law, and they are not bound by the fundamental rights. The state, of course, could not prohibit such an expression of opinion of the AfD. The state never could. Yeah, and we had the case that a mayor of a city, of Düsseldorf, he said, he posted a message and said, let's all take part in a demonstration against let's say AfD.
Party,
yeah, let's say AfD, or it was Pegida, against Islamization. Yeah, so let's take part. All good citizens should take part in a demonstration against this left-wing movement or party. And my city of Düsseldorf, will put out the lights during their demonstration. So we all show that we don't like them. Yeah, and our Federal Administrative Court here in Leipzig, the highest administrative court in the Federal Republic of Germany, said this was illegal, that the mayor, as a part of the state, was not neutral about this right-wing movement, and he was not allowed to post this message and to say that everyone should take part in a demonstration against this party. So what I wanted to say by this example, the state never would be allowed to delete such a message, because the state is bound by the fundamental rights, but this company in general may do so, although it perhaps is not good for the for a free communication in the internet. If this company would be the only company, if this would be the only way to communicate online via the internet, this probably could be different. And you said, yeah, that if this is the only way to express your thoughts via internet, then it can't be, these posts could not be deleted. But I guess we wouldn't say that. There are several ways to express one's opinion. So again, I try to answer this question. Yeah.
Okay, thank you,
Thank you.
Professor Anders. Thank you, Ricky Khairu. Unfortunately, we run out of time. This maybe 15 minutes we offer the time from 1 hour. That's schedule of Professor Anders. Again, I thank you very much for your time, Prof. Anders. In your tight schedule, you still give time for us in Malang, in Brawijaya. Thank you for Konrad Schroeder. And we hope you can meet physically maybe next year's, I don't know, in Malang or in Leipzig. So we can meet and discuss together with the student. Okay, thank you again.
That would be very nice. Thank you very much and have a good time. And I very much do hope to meet you again. And of course, also the others, perhaps in Malang or perhaps even in Leipzig. So, goodbye.
Goodbye. Keep healthy.